Namaskar and good evening to one and all. The Indian Constitution is not merely a book of laws, it is a promise that justice will guide us, liberty will empower us, equality will unite us, and fraternity will strengthen us as one nation. With this, I, Srishti Mishra, would like to welcome you all on behalf of Akhil Bharatiya Adhivakta Parishad Supreme Court Unit to the third Justice L. Parvatha Rao lecture series on the topic 75 years later, revisiting First Amendment to the Indian Constitution. The Adhivakta Parishad Supreme Court Unit has been conducting this lecture series as an ode to the Honorable Justice late Shri S. Parvatha Rao ji, who was not only a legal luminary but also an important pillar of strength for the Parishad as well. With this, I would like to extend a warm welcome to our esteemed guests for the evening. Our guest of honor, Honorable Mr. Justice N. Nagresh, retired Judge, Kerala High Court. Welcome, sir. And our guest speaker for the evening, Dr. Devashish Bharuka, Senior Advocate, Supreme Court of India. I welcome you all on behalf of the Adhivakta Parishad Supreme Court Unit. Now, before we start with the lecture, I would like to give a brief introduction of Justice N. Nagresh. Honorable Justice N. Nagresh obtained his law degree from Bombay University in the year 1989, and he was also awarded the Dr. Kelkar Award for his dissertation on the subject Transfer of Properties Act. He did his post graduation from Government Law College, Kerala, and he also holds a bachelor's degree in science from the University of Kerala. Sir started his practice in the chambers of senior advocate Sri O.V. Radhakrishnan, and after he commenced his independent practice, he has appeared and conducted number of cases involving constitution law, administrative law, service law, labor law, tax laws, and many other. He was engaged as a standing counsel for various public sector undertakings as well, like BSNL, Indian Tourism Finance Limited, Mysore Paper Mills, National Council for Applied Economic Research, etc. Sir has also served as the Assistant Solicitor General of India in the High Court of Kerala from July 2014 till November 2018. He was appointed as an additional judge of the High Court of Kerala on 5th November 2018 and as a permanent judge with effect from 14 September 2020. During his tenure, Sir has given and authored notable judgments on many important questions of law, some of which are Glanis versus Lazar Manzila, Sebastian Thomas versus Secretary, Rakul Krishnan versus Union of India, Sujit Prasad versus Reserve Bank of India, and many others. With this, I would like to invite Honorable Mr. Justice N. Nagresh, sir, to enlighten us with his words.
A very good evening to all who are participating in this virtual conference on 75 years later, revisiting First Amendment to Indian Constitution as a part of the law lecture in commemoration of Justice Parvatha Rao. I appreciate the action of the Adhivakta Parishad Supreme Court Unit for holding such annual lecture in commemoration of Justice Parvatha Rao. Justice Parvatha Rao was fondly called by all of us as Parvatha Rao ji. Was a man of character, conviction, and an ideal lawyer, judge, and human being. He was born in 1935 on 26th of November, which we commemorate as Law Day subsequently after our independence. He was enrolled as an advocate in the year 1961 under Dr. Sri D. Narasa Raju, who was a former Advocate General of Andhra Pradesh High Court. He practiced also under Sri N.V.B. Shankar Rao Advocate and Advocate Raghuveer, who later was elevated as a judge of the Andhra Pradesh High Court. Justice Parvatha Rao was appointed as a judge in the Andhra Pradesh High Court in the year 1990 and continued to hold the constitutional post till 1997. After his retirement, he was the chairman of the State Consumer Forum of Andhra Pradesh. I had the luck and opportunity to work under his guidance, while he was the national president of the Adhivakta Parishad, Akhil Bharatiya Adhivakta Parishad. Parvatha Rao ji was a man of immense courage and ideological conviction. I remember that Justice Parvatha Rao was very close to Justice Shivaraman Nair, who was the Chief Justice of Andhra Pradesh High Court and who was from the Kerala cadre of judicial officers. Full stop. Whenever Parvatha Rao ji visited Kerala, he used to go to the house of Justice Shivaraman Nair. Justice Shivaraman Nair's daughter, Justice Anu Shivaraman, is a senior judge in the Karnataka High Court now. Full stop. From the very beginning, Justice Parvatha Rao felt commitment to the social cause, which led him to the work of Rashtriya Swayamsevak Sangh. After joining Rashtriya Swayamsevak Sangh, late Parvatha Rao became the Kshetriya Sanghachalak of RSS. While working as Kshetriya Sanghachalak, Justice Parvatha Rao's name was recommended by the then N.T. Ramarao government for appointment as judge of the Andhra Pradesh High Court. Justice Shivashankar, who was the then law minister, insisted that for appointing Justice Parvatha Rao as a judge of the High Court, Justice Parvatha Rao has to give a letter disassociating with the Sangha work. Justice Parvatha Rao flatly refused and told the law minister that once he becomes judge, he will be disassociating with all organization. But before appointment as a judge, the law minister cannot insist for a letter of disassociation with RSS, which is an apolitical cultural organization. The strong stand and the conviction of Justice Parvatha Rao delayed his elevation to the Honorable High Court of Andhra Pradesh for not 2 and 3 years, but for 5 years. Full stop. To understand the humane mind of Justice Parvatha Rao, one should know that before he became a judge, he donated his land to Vijnana Bharati to start a school. He donated 27 acres out of his share of 30 acres to Gautami Seva Samiti and Gau Seva Samiti. Full stop. After becoming a judge, and after his retirement, he raised 1 crore rupees to construct a school building and donated another 10 lakhs rupees from his pockets to run the school. Before his demise, he donated 280 square yards of property, which was the last piece of land remained in his name. The property was adjacent to a national highway, and it was donated for construction of organic cow products by Justice Parvatha Rao. Before going from this earth, Justice Parvatha Rao donated every piece of land for social cause. On his demise, one of the senior lawyers commented that preaching ideals or morals is very easy, but practicing it is most difficult. Parvatha Rao ji in his lifetime showed that you can walk the talk and you can practice what one preaches. Full stop. A famous Sanskrit words is like this: Paropakaraya duhanti gava, Paropakaraya phalanti vriksha, Paropakaraya bahanti nadya, Paropakaraya midam shariram, which means rivers flows for the benefit of others. Cows give milk for the benefit of others. Trees give fruits for the benefit of others. And man should live for the benefit of others. Full stop. And Justice Parvatha Rao is an ideal idol for the judges and lawyers to emulate. That is why I said the Supreme Court unit of Adhivakta Parishad requires special commendation for holding an annual law lecture in commemoration of Justice Parvatha Rao. Today, we are having the lecture on the history of First Amendment to the Constitution of India. Full stop. The history of the First Amendment to the Constitution is interesting. Full stop. Crossroads was a magazine published by Ramesh Thapar. Mr. Ramesh Thapar, late Mr. Ramesh Thapar, was a left-leaning citizen. He took up the issues of atrocities against communist activists, their plight in Salem Central Jail, and extrajudicial killings in Madras of communist activists. On the basis of the articles published in Crossroads, the government banned the journal Crossroads, invoking the Madras Maintenance of Public Order Act. The allegation against the journal and later Ramesh Thapar was that Crossroads was inciting public unrest and offences. Full stop. The ban was challenged before the Honorable Apex Court. The Supreme Court held that censorship cannot be imposed on the grounds of inciting public unrest and inciting offences in view of the strict language of Article 19 of the Constitution of India. Therefore, the government took a stand to amend the Constitution of India for the first time. We must remember that the Constitution was amended for the first time within 1 year of its coming into effect, and even before an elected parliament was in place. Full stop. By the amendment, the public order and incitement to an offense were made to restrict freedom of speech. Full stop. The Article 19 stated that endangering security of state is a sufficient ground to curtail the freedom of speech. Full stop. In the European constitutions, like Constitution of United States, in this regards, the words used for restricting public speech was that clear and present danger, which means that you can curtail freedom of speech and expression if there is clear and present danger or a clear and imminent danger to the security of the state. Full stop. Instead of that, the Article 19 adopted the words endangering the security of state. This was the first amendment, or I would say that it was the first assault by the state towards freedom of speech and expression. One must remember that at the very same period, a gag order or censorship was imposed on the weekly called Organiser. Ramesh Thapar case and Organiser case, which is Bridge Bhushan versus State of Delhi, were heard during the same time. Organiser was a journal started on 3/7/1947, that is before India's independence, by Bharat Prakashan. Organiser held a big part of Latifi Press, a press which published the famous daily Dawn since 1933. It is this press which published the then popular Illustrated Weekly of India. After 31 1948, on which date Mahatma Gandhiji's assassination took place, the Rashtriya Swayamsevak Sangh was banned, and the Organiser also had to stop its publishing work. Subsequently, in 1949, the ban on RSS was lifted, and the Organiser resumed its publication. It was at this time that the refugee issues in India, Pakistan and Bangladeshi refugees, were coming to India, and the government was not giving appropriate relief to the refugees. The journal Organiser took up the cause of refugees, and the then editor of Organiser, Sri K.R. Malkani, late Malkani ji, started raising 6 questions in each weekly issue of Organiser to the then Prime Minister Sri Jawaharlal Nehru. The questions were unanswerable. Naturally, these questions annoyed the then Prime Minister. During this time, a cartoon was published in the Organiser depicting Liaquat Ali Khan and Nehru, who were the prime ministers of Pakistan and India respectively. The cartoon had a caption of "Villaiancy of Pakistan versus foolishness of India." The cartoon was in the backdrop of the situation that the Pakistani state was not soft towards the Hindu refugees flowing to India. Jawaharlal Nehru, the then Prime Minister, was taking steps for confidence building measures between India and Pakistan. In the Organiser, Sri late K.R. Malkani wrote about the villaiancy of Pakistan and said it is matched only by the idiocy of India, meaning that the Pakistanis are villains and the Indian state is acting like idiots by resorting to the confidence building measures when the refugees were driven out of Pakistan purely on religious considerations. This cartoon was the last straw on the camel's back. The government immediately issued a gag order and required the Organiser journal, Organiser Weekly, to give the articles to be published in the Organiser for pre-censorship. Full stop. The Malkani ji gave the contents of Organiser for censorship. Some parts of the articles were censored also. But when it was published in Organiser, wherever that censor was made, cut was imposed. Malkani ji put in bracket that this part is censored by the government of India. This further annoyed the government of India. In the month of April 1950, the organizer filed, or Sri Brijbhushan filed, a writ petition in the Honorable Supreme Court of India. Full stop. The matter was heard along with the case of Ramesh Thapar versus Union of India. Judgments were given together on the same day in both the cases. But Ramesh Thapar case, because it was reported in law journals or because it was certified for reporting, got more prominence than the Brijbhushan case. Full stop. I would say that Brijbhushan case, Brijbhushan versus State of New Delhi, was a better case for deciding on the issue, because the journal Crossroads and its editor Ramesh Thapar was supporting divisive forces. They were supporting communist unrest. The journal itself wrote in an article that the 1947 independence is continuation of imperialist policy under a different garb, meaning that the 1947 independence of India is not real independence. The journal also described the Constitution of India as a slave constitution. You should keep in mind. The Crossroads described Indian Constitution as a slave constitution. On the other hand, the journal Organiser was publishing article in the interest of the refugees who were driven away from the undivided Pakistan by the communal forces by force. These refugees, they were not infiltrators like the present infiltrators from Bangladesh. They were genuine refugees. They were not given shelter. They were not provided with food. They were not treated like human beings by the then state. It was this state of affairs that was protested, and articles were written in the Organiser. The journal Crossroads were supporting divisive anti-national forces who believed in armed rebellion against a slave constitution, according to them, which and the independence got by India was only a continuation of imperialist policy. So I am of the view that the facts of both these cases would show that it would have been more appropriate for the Supreme Court to pass a judgment in the case of Organiser rather than in the case of Ramesh Thapar versus Union of India. Friends, as far as freedom of speech and expression is considered, we must remember that there is always a conflict in the legal realm as regards the prominence or importance to be given to individual liberty or for social interest. The European countries, where initially the Anglo-Saxon law was developed, considered freedom of individual as the supreme quality of any democratic institution. The importance to the social cause was only secondary for the Europeans, which had a lesser population and which had fewer issues than in Asian countries. As far as India is concerned, in the Vedas itself, the Indian rishis told, or Indian legal system told, that the personal interest of a person should be subservient to the interest of a family. The interest of family should be subservient to the interest of their village. And the interest of village should be subservient to the interest of the nation, which in fact indicates that the interest of the society, the interest of the nation should be supreme and superior to the individual rights of liberty of citizens, especially in the case of national security and sovereignty and integrity of the country, we cannot compromise the national security and the sovereignty and integrity of Bharat and give more importance to the personal liberty. Giving this opinion, I conclude my speech, and I am eagerly waiting to listen to the senior counsel, Sri Devashish. Namaste.
Thank you so much, sir. That was really a very informative session for all of us. Now, before I invite our second speaker of the day, I would like to introduce sir to all of you. Dr. Devashish Bharuka is a senior advocate before the Honorable Supreme Court of India. He acquired his law degree from the Bangalore University Law College in the year 2000, after which he did his LLM from Harvard University. He was recently conferred doctoral degree by O.P. Jindal Global University for his thesis titled as Time as Jurisprudence, Indian Courts, Delays and Transformation of Justice. He has been practicing law in the Supreme Court since the year 2001. He became an advocate on record in December 2006 and was designated a senior advocate by the Honorable Supreme Court in January 2024. Sir is an empaneled arbitrator with the Delhi International Arbitration Center. Sir has also co-authored a book on constitutional history of India titled The Indian Makeover: From Being Ruled to Being Governed. The book captures the constitutional movements which had laid down the framework and foundations for Indian citizens to have participatory governance. Dr. Bharuka is also an ardent follower and user of technology in the field of law. His recent article on cautious use of artificial intelligence in legal research reflects his balanced approach towards legal research by using old school methods along with the help of AI. He has also conducted a master class for SCBA members on the use of liquid text by lawyers, which was very well received by all of us. With this, I would like to invite Sir to commence his lecture for the evening.
Thank you, Ms. Shrishti Mishra. Good evening, Justice Nagesh, and a very good evening to all my friends in Adhivakta Parishad, Supreme Court Unit. It is a matter of great honor and privilege to have been invited to deliver the lecture in the Justice S. Parvatha Rao lecture series. And I had the occasion of knowing more about Justice Parvatha Rao as Justice Nagesh was telling. And it is indeed a pleasure and honor to be here, and I'm truly grateful to Adhivakta Parishad for inviting me. And I must also congratulate Adhivakta Parishad, who has rightly chosen to discuss the First Amendment in the month of May 2026, exactly 75 years after this amendment was moved in the Parliament, and which had engaged serious deliberations and discussions between the top leaders at that point of time. The first moment this bill was moved on 10th of May 1951, and it was enacted by the Provisional Parliament, in fact passed by the Provisional Parliament in June 1951. It is quite fascinating, this journey of the First Amendment of the Constitution. In fact, I was just checking amongst in the world the fastest First Amendment, and it so happens that India actually had the fastest First Amendment within 16 months, and a very substantive First Amendment to the Constitution, barely 16 months ahead of having it adopted. And we all know that the adoption process itself was quite a long one. The draft constitution was debated for over 2 years, 11 months, and 17 days. It started sometime in December 46, and in January 50 is when the Constituent Assembly finally adopted, and it came into force on 26 January 1950. Now, one would truly expect that with the kind of intellectual people we had as members of the Constituent Assembly, and it was so intensely debated, with Dr. B.R. Ambedkar being the chairman of the drafting committee. And then we had all the stalwarts, intellectuals, many of the lawyers who were present and who had deep roots in the society and who knew precisely what New India wanted at that point of time. And those who had in fact participated in the independence movement had been through the length and breadth of the country, were from different parts of the country. So one would really expect that a constitution being built up on the shoulders of such giants would stand the test of time, at least for a few years before any amendments becomes necessary. And yet we see this journey that barely 16 months into the working, the First Amendment had to become. And that is exactly the story today we are here to discuss. Apart from the fact that the authority of the provisional parliament to amend this constitution, which will be an issue which I'll be looking into later. But as the constitution came into working and as things progressed, clearly the government of the day felt that there is something which is missing in the constitution, which is obstructing their ideals, which is obstructing their socio-economic, I would say, the reforms. And clearly there is something which probably was not anticipated at the time when the constitution was finally framed and adopted. And one would really wonder what those difficulties the government was facing at that point of time. Was it that there was some sudden change of circumstances? Was it there was a civil war? Was it that there was a change in the governance of the country? Was it the change of the party who was governing the country? What was it? Interestingly, it wasn't really that, but at the end of it was what I would call as the so-called what the government felt were the troublemakers. And the First Amendment, as we would see, was a direct legislative response to a series of judicial pronouncements that were perceived as obstructing the socio-economic policies of the government. Now, because the government was considering that we had just come out of the shackles of the British Raj, and they were keen that the centuries old socio problems across the country had to be looked into, particularly the agrarian reforms is what they were hoping to sort of introduce in a big way. It was the agrarian reforms which clearly had some troubles with the court, which led one of those to be amendments. As Justice Nagesh has already indicated about the Romesh Thapar case and the Brij Bhushan case. Now, these two cases clearly reflected upon how Article 19(1)(a) was perceived by the courts, where the courts believed that what they have to uphold is the rights, the fundamental rights of the citizens, and the restrictions which are provided has to be restrictively read. So anything beyond cannot be read into it, and therefore the Article 19(1) fundamental right has to be, at the end of it, enforced as and where possible. So the two judgments of Romesh Thapar and Brij Bhushan, Romesh Thapar with respect to the Crossroads magazine, and the Brij Bhushan, where the Delhi administration started imposing pre-censorship on the Organiser magazine. Now, these two ultimately, the Supreme Court struck down both the orders of the government, upheld Article 19(1)(a), and it said that the restrictions on freedom of speech and expression under the original Article 19(2) were permissible only on grounds of security of the state, which did not include the broader concept of public order. Now, this was one of the significant troublemaker, which probably sort of irked the government to see that how at some point of time, the private versus the public interest would shape up as you move forward. So this was one of the areas which sort of triggered the First Amendment. The second was particularly with respect to the reservation which was made in the government-aided professional colleges. Now, at that point of time, there was no specific reservation enabling provision in the Constitution for the purposes of socially and economically backward people. So therefore, when a Brahmin woman was denied admission to a government medical college in Madras, despite her better merit, because the Madras government at that point of time had issued a government order and they had reserved certain seats on the basis of caste, that came to be challenged. And the Supreme Court struck down that communal quota system, and it held that the caste-based reservations violate the fundamental right under Article 29(2). So this was the second area where the political establishment of the day wanted to actually have introduced some kind of an affirmative policy for the purposes of reservation, and through that to uplift the socially economically backward people. But then there was no such provision, and they realized that the Supreme Court at the end of the day would enforce the equality clause in case there is no such provision. So there was some kind of a realization that there is a vacuum to that effect in the Constitution. So Champakam Durai Rajan was the second set of judgment which sort of which sort of acted like a troublemaker for the government. The third was a completely different area. This was about the economic agenda and particularly the abolition of zamindari system. Now, zamindari system over the years, as we all know, has sort of spread through the British policy in a particular manner, so that there will be a lot of landless people who would ultimately be working under the zamindari system to the benefit of the zamindars. So the feudal land tenure structure, which was we inherited from the colonial rule, is what the government was keen to abolish immediately after the independence and when it came to power. It so happened that as and when they enacted all the zamindari abolition legislations, these laws also came to be challenged in the high courts. And these are challenged on the ground that they actually violate the right to property. Now, that again was a fundamental right under Article 31. Now, this fundamental right with respect to property is something which was again upheld by the courts, and therefore time to time there were matters there were zamindari abolition legislations, and they were all stayed by different high courts. So this was an area which again troubled the government in a big way. Another area I believe which troubled was with respect to Article 19(1)(g). Now 19(1)(g) is the fundamental right for carrying on business, trade, etc. The government wanted to monopolize, and this came actually from the Bombay government, where the Bombay State Road Transport Corporation, there was one of the cases which they wanted to monopolize the transport system. That was again challenged. It was found to be violative of Article 19(1)(g), but every citizen would have a right to actually carry on any trade and profession which they like. There was also another area about the nationalization, which again, the government had some kind of a trouble with the courts. So it was really this background where the government realized that there is on one side fundamental rights, which obviously is something which has been framed by the constitution makers just a few months back, and which is crucial for the purposes of individual citizen. But on the other hand, there are these policies ingrained in the directive principles of state policy, based on which there were legislations being made from time to time. And these legislations were now eventually being attacked by the citizens before the courts, and the courts were giving preference to the fundamental rights as opposed to the directive principles of state policy. And then they were being struck down. Those legislations were being struck down. So be it in terms of speech and expression, be it in terms of reservation, be it in terms of nationalization, be it in terms of zamindari abolition legislations, all of these legislations were actually being sort of stalled. And that's what the government felt at that point of time, that these policies are being stalled at the instance of the courts. Of course, they were very careful in not attacking the judiciary because they felt that that is how the judiciary is interpreting, maybe in the wrong manner. But they believed that an amendment now at this stage itself would be crucial because as there was an understanding that somehow the constitution itself is acting as an obstruction to the development of the country. But this was something which was very interesting, that the constitution, which was built up so carefully, drafted so carefully after more than 2 years of detailed deliberation, within 16 months, it was felt as if now it is already acting as if it is obstructing the course of development, overall development of the country itself. So this is where, because of these judgments, the solution which they really came out was with respect to introducing this First Amendment. Now, this First Amendment bill was introduced on 16th May 1951. And because there was a lot of criticism all across, the bill was referred by the Parliament to the Select Committee. The membership itself reflected a deep divide. It had the Prime Minister Nehru, it had Dr. Ambedkar, it had Mr. Rajagopalachari, and we had critics like Dr. Shyama Prasad Mukherjee, H.V. Kamal, Hridaynath Kujru, as a part of that Select Committee. After those reports came back to the Parliament, now what the statement of objects and reasons, which was reflected while introducing this bill, was that the government felt that during the 15 months of working of the constitution, there have been certain difficulties had been brought to light by judicial decisions in regard to the chapter on fundamental rights. So they were very categorically and clear that it's not that there is actually change otherwise in the scenario of the government or in the scenario of the country. They believe that because there have been certain judicial decisions, which has led to a situation where they're unable to implement their policies, which otherwise they were hoping to get it smoothly. And these are all in the context of fundamental rights, that ultimately they have no choice but to move this amendment. In fact, at the time of moving of amendment, what Nehru said was something interesting. He said that somehow we have found this magnificent constitution that we had framed was later kidnapped and purloined by lawyers. So clearly, Nehru believed that ultimately it's the law's genius which has led to the courts to be persuaded to return decisions in a manner which they believe was not really in the interest of the society. And then he also declared that the courts have been stressing fundamental rights over directive principles of state policy, and the resultant social changes was hindering the whole purpose of the constitution itself. So as we move forward, one would realize that really this fight was between enforcement of fundamental rights as opposed to enforcing of legislations which are based within the directive principles of state policy. So all this, as in fact Dr. Ambedkar during the assembly debates had said, the directive principles of state policy is nothing but instruments of instructions. So these are they would then be building up their legislations for the welfare of the people. So Nehru felt that those instruments of instructions should in some manner have precedence over fundamental rights. In fact, during the discussions for the First Amendment bill, he specifically said that he believed that fundamental rights is static in nature, whereas the instruments of instructions, that is the directive principles of state policy, they are dynamic. And therefore, the portion of the constitution which is dynamic must actually take forward so that that's how the country will move forward. But because of the courts taking a call or an interpretation where they felt that the fundamental rights is what has to be given precedence, therefore these difficulties have arisen, and therefore this particular First Amendment, as early as barely within a few months from the adoption, has now to be moved. So this really seems to be the foundation on which this entire bill has therefore been moved forward. So the belief that they had this interpretation of 19(1)(a) is something which is not good. There was a need to clarify the Article 19(6) for the purposes of placing nationalization beyond doubt. Then there was a need for Article 31 in some manner to be amended so that the agrarian reform can move forward. There was a need also to protect special provisions for protection of backward classes for the purpose of reservation. So now there were categorically for this discussion 5 key changes which the First Amendment brings about. The first is with respect to the expanded restrictions on free speech. So Article 19(1)(a) already gives this fundamental right of speech and expression. 19(2) provides for certain restrictions, but considering the experience of the government with the courts in Romesh Thapar and in Brij Bhushan, what they did was then they introduced these new grounds, 3 new grounds. One was restriction with respect to friendly relations of foreign states. Second, public order. And third, incitement to an offense. And then what they also did was they introduced the word reasonable with respect to all the restrictions. So therefore, the restrictions itself is not good enough. There should be reasonable restrictions so that then there could be some kind of a justification in case somebody is challenged. It can be justified by the government that these are reasonable restrictions considering the circumstances in which those restrictions are being imposed by way of law. So it is this one word of restriction which also helped in sort of maintaining the judicial review. And as we move forward in the last 70 years of our experience now, we see that the word reasonable really has been constitutionally and constantly being interpreted in different manner. Doctrine of proportionality, etc., has been introduced. So the jurisprudence has built up on the word reasonable itself. And after a while, sort of reading 14, 19, 21 altogether, the word reasonable has come up with some kind of a serious jurisprudence for the benefit of the citizens as also for the benefit of the government. So Article 19(2), there was expanded restriction. That was one of the amendments proposed. Next was Article 15(4), that is affirmative action. So that was it was inserted as an exception to 15(1) and 29(2), and it enabled the state to make special provisions for the advancement of socially and educationally backward classes, scheduled castes, and scheduled tribes. This again, I think, really became the foundation in the years to come with respect to India's reservation policy. This was the constitutional cornerstone which was introduced because of a judgment arising from Madras, and 15(4) as an affirmative action was introduced. Next was about creating a state monopoly and nationalization. And this, of course, was really the foundation with respect to all the nationalization laws which came about later in 60s and 70s. So Article 19(6) expressly then authorized state monopoly and nationalization of any trade or industry, and it removed all doubt with respect to such validities. So nationalization was something which was constitutionally protected by way of Article 19(6). Article 31, capital A, was an interesting introduction. It was for the purposes of protection of agrarian reform laws. So it related to the acquisition of estates, which was placed beyond the challenge under the equality and freedom and property right provisions. And then it was immunized from Article 14, 19, and 31. So 31A really was in terms of furtherance for the agrarian reform laws, which the government wanted from day one, but could not do so because of the constant judgments of the high courts, etc., staying those laws or setting them aside in view of the fundamental right to property. So that was an exception created. Now, 31B and 9th schedule was something which probably would have been started with some kind of a positive note, but as the history shows, it was kind of misused in the years to come. So Article 31B, it indicated that the laws which are placed in the 9th schedule were immune from judicial review on the ground of fundamental rights. So this is where all these law reforms, especially with respect to land reforms, etc., were placed in the 9th schedule, and that gave a complete immunity with respect to those laws and cannot be touched by the courts at all. As I move forward, we will also discuss IRL Kohilo, the aftermath, where finally there was some kind of a dilution to 9th schedule, but it took quite a while. This particular thing started with the 9th schedule started with 13 laws initially. By the time in 2007, it had gone to 284 laws. So there were a lot of variety of laws. It started with agrarian laws. It moved on to non-agrarian laws as well. So now during this discussion, the principal voices, as we see, of the debates, number one, of course, was the person who had really started, Prime Minister Nehru. But he had to actually answer one thing which was very important, was whether the government of that day and the parliament even had the power to amend this kind of a come up with this kind of a First Amendment. And the reason was this: under the Government of India Act 1935, the elections had taken place on some restrictive franchisee. Now, when there was a situation came about for election of the members of the Constituent Assembly, they realized that a direct election would be very difficult in the circumstances in which India was at that point of time. So there was an indirect election by these legislative assemblies and the Central Legislative Assembly, and they had then chosen the members of the Constituent Assembly. And the Constituent Assembly assumed the legislative powers for the purposes of making the constitution. But post-independence, it also acted as the provisional parliament. Now, this question came about because in the winter of 1951, we had the elections coming up. And yet in May 1951, this First Amendment was moved, which was effectively having drastic steps in terms of the fundamental rights, which otherwise was secured in favor of the citizens barely 16 months back. So there was a huge heated debate during this entire discussions on the bill, whether the provisional parliament is the right authority to actually proceed and go ahead with the amendment. Of course, as we all know, despite all the objections made, at the end of it, the parliament did proceed to pass the First Amendment bill. But this was one of the initial objections which were raised by almost all the critics of the First Amendment. Now, in terms of the debates, as I said, Jawaharlal Nehru was quite clear. He openly admitted that though the fundamental rights are of greatest importance, he said that a distorted liberty is not democracy. And he categorically stated that it is ultimately the directive principles of state policy which are dynamic in nature, and that they are the instruments for achieving social and economic transformation. And he was in fact concerned. He said that the constitution has become a paradise for lawyers. Again, it was really in terms because it was the lawyers who were going to the courts for the benefit of the citizens to enforce the fundamental rights. And the courts, rightly so at that point of time, gave preference to the fundamental rights. So that is an area which Nehru, I believe, as I said in the beginning, this really First Amendment was all really about, at the end of the day, the fundamental rights chapter versus the directive principles of state policy, and as to which will have precedence. And because the courts were giving precedence to fundamental rights, the government of the day believed that let us actually amend the fundamental rights itself and put certain restrictions so that we are able to actually take a sort of dilute the impact of the fundamental rights on the laws and the legislations being made in furtherance to the directive principles of state policy. Dr. Shyama Prasad Mukherjee, he was one of the strongest critics of this particular bill. In fact, he saw this as a power sort of grabbing area. He believed that that we are unnecessarily moving forward with indecent haste. It was not really required. And secondly, he believed that in a way the government is actually assuming more power than what it should really have. And when we have just 16 months back built up a constitution, keeping in mind all this, there was no reason that we should actually now dilute it at such an early stage. And in fact, he even indicated that the leaders who had fought for colonial censorship are now defending wider restrictions on speech itself. So his speeches, in fact, are worth reading. They run into pages after pages, but those reflect the strongest parliamentary defenses for free expression and speech, as you would find. Dr. B.R. Ambedkar, of course, defended the amendment. And there was a very interesting argument of Dr. B.R. Ambedkar. So at the time when fundamental rights chapter was being built up and the restrictions were being placed, he said that in the American Constitution, there is no such restrictions. So it is only fundamental rights. So the courts adopted the doctrine of implied power or police power and introduced restrictions through judicial precedents. And in fact, he said that that is the justification that instead of waiting for the courts to do so, in India, we should have our own restrictions inbuilt so that we need not wait for the courts to do it. The government of the day would know where the restrictions lie, and the citizens would know to what extent the fundamental rights they have in their favor. Now, interestingly, in this particular amendment, while moving, he said that the Indian courts have failed to apply the doctrine of police power and implied powers. In fact, this was something which was pointed out by Dr. Mukherjee as to how Dr. Ambedkar's stand at the time of drafting of the constitution seems to have now changed for the purposes of this First Amendment. But Dr. Ambedkar, of course, supported that. And Shri Kriplani, he delivered again one of the most powerful critiques. And he said that it is morally incorrect, really, at this point of time to make such drastic amendments in the constitution when we are still attempting to see as to how the constitution would work out. So there was clearly a very deep divide in between the supporters and the critics of this First Amendment. And there was a foundational ideological conflict within the constitution itself, as the debates reflect. Because Prime Minister Nehru, he feared that the rigid judicial protection of individual rights would preserve economic inequality and social privilege. However, the others took a stand that at the end of it, the fundamental rights are there. The directive principles of state policy are mere instruments of instructions, and therefore it is not necessary that any law built up in view of the directive principles of state policy are bound to be good law. And therefore, to be able to have these kind of amendments where we have the ninth schedule, etc., which is completely protecting them from judicial review, is something which should not be permitted at all. But at the end of the day, it was passed. And in fact, I found there was one professor, this Professor Upinder Bakshi. In fact, he said that he called this First Amendment bill as the second constitution, or the Nehruvian constitution. So there have been a lot of discussions and debates over the years with respect to the First Amendment. This is how, as I said, the troublemaker, the judicial decisions is what the government saw as the troublemakers and the reason for having the First Amendment. And then these First Amendments came about in terms of these aspects. But the real issue is now, after 75 years, what have we learned really in terms of how this First Amendment, and especially those who I have indicated, the fundamental rights, how have they worked out in the last 75 years? I think that is something which would be interesting to see. And to see that how this amendment has shaped the subsequent history of the Indian constitutional law. So one, of course, the first thing, the objective was, at the end of the day, whatever Prime Minister Nehru indicated or whatever the government of the day said, it was at the end of it to overcome certain judicial decisions by constitutional amendment. That was quite obvious at that point of time. And because that became like a precedent, there were follow-ups where they were later replicated through the same process from 4th, 17th, 24th, 25th Amendment, 40th, 42nd Amendment. So all these amendments clearly were used for the purposes of overcoming judicial decisions which the government felt is uncomfortable for them or for the society or for the country at large. So that's one thing we should take from this, that these precedents have actually this particular First Amendment principle, this precedent has created that. Second, I think it's very important, which came about, was that the parliament at that point of time attempted to have more power being created for itself. In fact, Nehru said that maybe the provisional parliament is not the right body right now to have First Amendment. But he said, no, but morally we are right in what we are doing, because we are not saying that we are creating power. We are only reminding, yes, we have this power. And therefore, whatever be the judgments of the court, of the High Court, or the Supreme Court, we should be permitted to be able to have these amendments made. Interestingly, it is this particular first bill which ultimately led to the pronouncement of the doctrine of basic structure by the Supreme Court. Now, the validity of the First Amendment was challenged in Shankari Prasad Dev, and it was upheld. They held that the Parliament has the power to amend Article 368 in whatever manner it wants under Article 368, and that the word law under Article 13(2) does not cover this constitutional amendment. So Shankari Prasad clearly gave all the power to the parliament to amend whatever they want in terms of the constitution. And subsequently, in Sajjan Singh, Supreme Court again reaffirmed that, though there were two dissenting justices who questioned a complete power being given to the parliament. Then the third one was IC Golaknath, where there was a change and where the parliament, they held that the parliament cannot really amend everything they feel they can amend. But ultimately, it all led to Keshananda Bharati, which was, I think, the most important and the watershed, where they laid down the basic structure doctrine and said that cannot be altered or destroyed. As time progressed, over time, the basic structure doctrine itself developed further by Supreme Court from time to time. But what really is the takeaway is that it is because of this first bill that there was at least a serious debate and discussion within the Supreme Court itself, right from those early 60s, where they saw that what exactly could be the power of the parliament and whether there are any limitations of the power of the parliament for the purposes of amendment of the constitution itself. So right in the beginning, since right from day one, as we had seen the first bill, this doctrine got developed because of the first bill at the end. So this is something which came about as an interesting takeaway. Third point was about the ninth schedule. The ninth schedule had always been troubling from the day it came because it was a complete shield from judicial review. Now, judicial review is something which is really the cornerstone of the constitution. During the assembly debates, it was said Article 32 is the heart and soul of the constitution. So everybody believed that judicial review with respect to every action of the state is something which is necessary. Ultimately, of course, in L. Chandrakumar, Supreme Court said it's part of the basic structure. But then in the ninth schedule, the way it was framed, initially there were 13 laws and eventually 284 laws. And in fact, I was looking into the kind of laws, and initially the focus only was on agrarian reforms, the way the intent was for the first bill, that they need to ensure that there is agrarian reforms in the country, and there was zamindari abolition, and now these laws are being struck down by the court, so let them make it judicially immune. But as things move forward, there was expansion into non-agrarian laws itself. And those is where the troubling probably factors started coming about. And ultimately it led to the judgment of the Supreme Court in IRL Coelho, where they said the 9 judges of the Supreme Court categorically held that even though the ninth schedule is sort of limiting the judicial immunity, it cannot completely be nullified. It has to happen that in case there is any law which is actually affecting the basic structure, to that extent, even the law within the ninth schedule can be looked into. So all those laws which otherwise they had expanded, the nationalization laws, industrial regulation laws, the emergency legislations, reservation laws, all things were put into those 284 laws within ninth schedule. In the long run, with IRL court judgment, I think that is also got diluted. So that's another area which has, I think, in terms of constitutional development of the country, in terms of the theories and principles coming up, ninth schedule and its dilution is also an important takeaway, and all because of the first amendment. Now, I think one of the most important foundations that the First Amendment laid down was the affirmative action in India. With the insertion of Article 15(4), it became the constitutional cornerstone for India's reservation policy. And as we move forward, we are all aware we had the Mandal Commission report, Indira Sawhney judgment, and then the M.R. Balaji judgment, the 2005 constitutional amendment, which provided for extending reservations in educational, private educational institutions. So all this entire reservation, which otherwise would have probably been left out on account of only government orders or executive orders in Article 162, I think Champakam Dorai Raja's judgment, which finally led to this amendment, had a major impact on how the upliftment of the social and economically backward classes in India would have happened, which again was, to my surprise, one would have actually expected this provision to be there right in the beginning when the constitution was being framed. We have also already discussed about the agrarian transformations and how this has enabled the transformation from the pre-colonial history, and how the zamindari abolition took place, how there was sort of landless people who were given lands, the millions of tenant farmers who obtained rights over land. So those in Article 31A and 31B provided that kind of a constitutional foundation and insulation for these reforms. And another area which I would not say is a direct outcome of the first bill, but at least clearly challenges the notion of Nehru at that point of time, that the fundamental rights are static in nature and it is the directive principles of state policy which are dynamic. Clearly, over the years, the Supreme Court has, contrary to Nehru's characterization of fundamental rights as static, has given judicial interpretations to each of these fundamental rights under the fundamental right chapter, particularly Article 21. So this is an area which has truly developed, though in an indirect manner, but considering the thought process of the government of that day and the reason why they had actually introduced, one of the reasons they have introduced the First Amendment bill. I think today, with this interpretation, we all know that both the directive principles of state policy as the fundamental rights, both are sort of equally being expanded and by the Supreme Court. And another principle, in fact, because of this restrictions, etc., is the doctrine of proportionality, which has come through while we are looking at the fundamental rights versus the restrictions. In fact, the Supreme Court has said that it is the rights which are fundamental and not the restrictions. So again, this seems to be in furtherance to what Supreme Court had said at that point of time while passing those judgments which led to the first bill. But even today, considering that the restrictions are still there and new restrictions, but there's always some kind of a balance which the Supreme Court does and some kind of doctrine of proportionality which is applied time and again for the purposes of ensuring that the fundamental rights are not affected. So now what is really striking, which I find in this entire First Amendment, is that, again, as I said, despite the Constituent Assembly having taken nearly 3 years to deliberate, still there were these areas which for some strange reason, they fell short in anticipating and considering that these are the areas like the upliftment of the backward classes, of agrarian reforms. Some kind of anticipation one would have expected, which would not probably would have obviated the need for even this First Amendment. Maybe the courts, the Supreme Courts would have reacted in a different manner had these provisions already been there at the first stage in the main constitution when it was framed. So that itself should have been there. Second, very interesting as the debates one would go through, is that it was these people who were otherwise, at the time of framing of the constitution, were actually sitting together wanting to frame the constitution for the benefit of the country. It was the same people who fought against the colonial rule. It was the same people who had actually fought for rights which otherwise the British Raj never gave to them. And therefore, these were the people who ensured that these fundamental rights are secured within the constitution itself for the benefit of the citizens. And still, now that once they came, as I say, from into the ruling party or the opposition, they were not acting as revolutionaries anymore. But one part was acting as state and one was acting as the opposition. And it is during this governance system that the state suddenly realizes that maybe what was happening earlier in terms of restrictions to the rights of the citizens was morally and legally correct than what it was when they felt they are from outside and opposing it. So that is something which is also quite intriguing and interesting to see. And Nehru believed all through and through that he has been protecting democracy in this process. But whatever be the outcome at that point of time, whatever has happened, in the long run, clearly in the last 75 years, we have seen that all these amendments have actually been a catalyst for the purposes of, important constitutional developments in the country, of developing the constitutional jurisprudence of the country in a big way. So the serious constitutional argument has been there. This argument goes on whether this bill was right or wrong. But as we have seen, the after effects of the bill has, in a big way, I would say, altered the way we have been seeing the constitution itself, how the courts have been seeing, how the citizens have been seeing. So this is really, in short, sort of the perspective of the First Amendment bill. And I'm truly grateful to Adhyavakta Parishad, Supreme Court Unit, for inviting me for this lecture series. Thank you.
Thank you so much, sir. That was truly an interesting take on today's topic, and it was quite enlightening for all of us. Now, I would request Akansha Kashyap ji to give the vote of thanks and conclude today's evening.
Good evening, everyone. On behalf of the organizing committee of Justice S. Parvatha Rao lecture series, it is my privilege to deliver the vote of thanks for this thought-provoking sessions on 75 years later, revisiting First Amendment to the Indian Constitution. We are deeply honored by the gracious presence of our guest of honor, Honorable Justice N. Nagaresh ji. Sir, your reflections on the continuing relevance of the First Amendment have given us clarity and direction. We're grateful for the generous time and insights that you shared. I extend our sincere thanks to Senior Advocate Dr. Devashish Barukaji for such a thought-provoking session. Sir, your vast experience, knowledge, and guidance have provided us with immense learning and motivation. My sincere appreciation to all the members of the organizing committee whose tireless efforts, planning, and coordination made this session successful and seamless. Thanks to everyone who joined us today and contributed thoughtful comments. As we conclude, let us carry forward the insights shared by our distinguished guest this evening. I now invite Srishti ji to bring this session to a close.
We'll close this session with a mantra. So I would request Aditya ji to take forward that and conclude our evening for today.
Om Sarve Bhavantu Sukhina, Sarve Santu Niramaya, Sarve Bhadrani Pashyantu, Ma Kasyat Dukha Bhag Bhavet. Om Shanti Shanti Shanti. Thank you.
Thank you to everyone who was present here today. And with this, we conclude today's session. Thank you.
Thank you.